So when do you appeal and when do you file a writ petition? So of course, appeals are governed by CCP 904.1. You look at that and you go, okay, these are all appealable orders and judgments, and anything that's left over is subject to writ petition. Yes, but if something is appealable and appeal will not be adequate, you can also file a writ petition. So if you have an appealable order, but you just can't wait and supersedious won't work for you, you can file a writ petition. The difference between an appeal and a writ, of course, is that the court has to review an appeal, and it has absolute discretion over a writ petition. So an appeal is considered to be a legal remedy. That is, we have law and we have equity, and there are legal rules, as you all know, about appeals, and then there's equitable rules. And rules of equity apply in writ petitions, and that will be important, as I will demonstrate later. Now, I'm not going to talk about supersedious, which is ancillary to appeal, and I'm not going to talk about certiorari, but if you have questions about them, that'll be fine. So let's go over some of the nomenclature. So you have your petition, or your writ petition, or taking a writ. We always call them petitions of the Court of Appeal. Petitioner, that's the party that's seeking relief. Real party or real parties in interest, those are the other parties that are involved. And of course, respondent, which is the superior court, the trial court. Respondent court almost never gets involved in any of the proceedings in the Court of Appeal, except perhaps if it's a disqualification motion. Otherwise, even though things are direct, orders and rulings are directed to the respondent court, forget about it. I recently had an email from someone in one of my groups who said, I got this order to show cause, and it said that the respondent court had to show up. And does that mean that the trial judge is going to show up and have to argue? Like, no. It's rather esoteric, and you have to know the ins and outs, which is one good reason to consult with someone who knows appellate law when you have to go through all these. So when you file a writ petition, there are basically two kinds of writ petitions in the civil area. There are the statutory writs and the non-statutory writs. In the statutory writs, you should have gotten materials that has the heading of statutory deadlines. And on the fourth page, I believe, it has the 60-day rule. That's the second set of materials you should have gotten. Those are that's the exhaustive list of the statutory writs statutes that authorize writ petitions for various and sundry motions. So you have your motion to disqualify a judge for cause or a peremptory challenge. You have venue. You have summary adjudication, summary judgment denied. It's all there, and please take a look at it. Keep it for reference, because I've compiled everything that's disparate from the different statutes, and you have it there on 4 pages. So those are the statutory, and then anything that's not in 904.1, or even if it is, as I said earlier, is subject to a writ. So what would that be? So that might be if your demur is overruled, if your discovery order is denied, or if discovery is granted against your client. So those are the types of motions that don't fall within 904.1 and are not governed by a statute. So when you have a petition that isn't governed by a statute, you have to show the court, and this is I think why you're all here, why it's so important that the court grant you relief. Why is it so important? What's going to happen? What's not going to happen if the court does not take your petition into consideration? That is, because it sits as a court of equity, the court again has discretion whether or not to take your writ petition. So you have to show many, many different factors. And some of them are weighed more heavily than others. What's interesting is that you can find all these factors in a pretty old Division 6 case called Omaha Indemnity, and it's cited in your materials. So what are these issues? What are these factors? One, the issue is of widespread interest or presents a significant and novel question, maybe even constitutional. The trial court's order deprived one of the parties of a claim or a defense. There are conflicting trial court or appellate court interpretations of law. The trial court's order is erroneous as a matter of law and relatively easy to fix. The party seeking the writ has no other legal recourse. Legal meaning, of course, not in a court of equity. There's no appeal. And most importantly, that the petitioner would suffer harm or be substantially prejudiced. That's the most important factor. And when I say that, it doesn't mean that when you write your petition, you say, this poor person for whom we must feel a lot of sympathy cries. Of course not. And you, of course, all know that, although I've seen plenty of petitions where it's almost like a fictionalized story. It's always good to tell a story. It's important to tell a story and tell a truthful story. But basically, the court is not swayed by, I don't mean poor as in financially poor, but look at my unfortunate client. What you need to do is show that in the litigation there's a real problem. That's very important. So for example, let me show you that if for example, it's on a complaint and the person has filed a complaint that's basically claiming a breach of contract, and there's 3 or 4 contract causes of action, and then there's a couple tortious breach of contract claims. So if the trial court sustains a demur to one of the tortious, I've seen this, tortious causes of action for breach of contract, the Court of Appeal may say, well, you know, the facts are still there. You're still able to bring up the same evidence because you have these other 3 claims of tortious breach of contract. So the Court of Appeal isn't going to step in at that time to reverse that ruling, even if it might seem erroneous to you, because the client, the plaintiff, will not be irreparably harmed by allowing that to go forward. However, if you have only one tortious, have only one cause of action for tortious breach of contract, for example, and that gets knocked out, the court is more likely to take a good hard look at that to make sure that the plaintiff has the ability to go forward. And that is true also when it comes to the defense. So if, for example, your affirmative defense or another defense that the statute of limitations ran before the complaint was filed, if there's a jurisdictional issue, the court will also take a good hard look at that because perhaps the whole case shouldn't go forward. And of course, that would be when it's denied. If it's granted, then of course you have an appeal.